Hey gang, welcome to Facts and Firearms. My name is Massad Ayoob, and today we're going to talk about something that comes up often in court in self-defense cases, the problematic Federal Rule of Evidence 404B. The general public tends to think if they're attacked by a violent criminal and they fight back and harm him, perhaps even kill him in self-defense, that the courts will say, well, you're the clean citizen with the concealed carry permit. This guy was the criminal with a record as long as his arm. That's it right there. It doesn't work that way in this country. It might work that way in other countries. One that sticks in my mind from the mid-1980s when I was down in Caracas, Venezuela. Incident with my friend Fernando Arcaya. Fernando was going to lunch. He's walking through a parking lot at midday and encounters a criminal who is about to die from what I've come to call sudden and acute failure of the victim selection process. He pulls a knife on Fernando and says in Spanish, "This is a stick-up." And Fernando looked at him and said, "Stick-up. Stick-up. Bam, bam!" I drew his Browning high power from appendix carry, shot the guy 3 times. The guy was dead before he hit the ground. It went that day in front of a judge, much faster than you'd be likely to see it happen here. The judge by that time had the dossier on each of the involved parties right there in front of him. And he sees here is Fernando Arcaya. He is a martial artist and a gun expert who teaches police, has fought for his country. And here is the deceased. I was told that the judge unfurled the computer printout record of the suspect, and it was literally the proverbial record as long as your arm. Said something to the effect of, "My God, his record is longer than his life," which was kind of true at the moment. Turned to the investigators and said, "Do you have the citizen's pistol?" They said, "Yes, we have it here." I said, "Give him back his pistol." He looked at Arcaya and said, "Citizen, this difficult day is over for you. Go to your home. This matter is done." And that is the way it probably should have gone. And it's the way you think it's going to go here, but it's probably not. Federal Rule of Evidence 404B means that prior bad acts by the opponent who forced you to harm him, if they were not known to you at the time you harmed him, can generally not be included in your defense and shown to the jury or even considered by the judge. And the rationale for that is, if you didn't know it, it was not formative to your decision and your actions for which you're now being judged. And we can all understand that. At the same time, in the big picture, when the other side says, "No, we don't believe that he was attacking you. He was a nice guy who never would have attacked you," an argument like that actually can open the door for the judge to set aside Rule 404B. Let's go back to 1984. I was expert witness for the defense in the state of Florida versus Officer Luis Alvarez case. Alvarez had shot and killed a young man he was arresting for illegal concealed carry. When the young man spun on him, went for the gun as if to shoot him and his young rookie partner, and Alvarez fired the single shot that ended the young man's life. It was a cross-racial shooting, triggered the second largest race riot in Miami history, and apparently the community needed a scapegoat, and Alvarez was charged with manslaughter. The prosecution had made the mistake of painting the deceased, Neville Johnson, Neville Snake Johnson, Snake was his self-given nickname, which was kept out of trial. The jury never knew that because it wasn't known to the officer. They had painted him as a 20-year-old courier with a clean criminal record, which was pretty much true. He hadn't been caught yet. But that argument that he's a sweet, innocent person who would never have attacked a police officer, or the implication of same, is what opened the door for the judge to set aside 404B. After the late, great attorney Roy Black and his co-counsel on the case, the equally skilled Mark Seiden, had prepared a 40-page memorandum of law urging the judge to set that aside. Well, with that set aside, the defense was able to bring in front of the jury an elderly black woman who testified very graphically and very dramatically how she had recognized the face of Neville Johnson when it appeared in the newspaper after he was shot and killed as the man who had terrorized her in an armed robbery. And I was told that when the prosecution tried to impeach her by saying, well, you're just glad, admit it, you're just glad he's dead, she broke into tears and said, yes, after I learned he was dead, the nightmare stopped. And suffice to say, the jury acquitted Neville Johnson, acquitted Officer Alvarez on all charges, which led to the third largest race riot in Miami history, but that's what a city gets for electing someone who throws cops to the wolves with unmeritorious cases as their state's attorney. So go on the assumption you'll not be able to. Now, this doesn't mean that you won't be able to get it set aside. It means the other side has to do something to open the door. Also, we have some positive movement on that in a couple of different states. Two precedent cases from state Supreme Courts, actually three. Two come from the Commonwealth of Massachusetts. Commonwealth versus Pring-Wilson, if you're taking notes, is Pring-Wilson, common spelling. And Commonwealth versus Adjutant, Adjutant. We have a similar ruling from Arizona in the case of Arizona versus Harold Fish. And those said, in essence, if the actions described by the defendant, who didn't know him, didn't know the deceased's history, if it turns out the deceased has a history of doing the exact same pattern of attack on others, the jury should know that to allow them to assess the credibility of the defendant. Now, if you don't live in Arizona or the Commonwealth of Massachusetts, obviously case law from their state Supreme Courts does not bind on the judge in your state. It is, however, useful as what's called persuasive argument to hopefully convince the judge to set that aside and let the jury see this is the history of the man who attacked the defendant, and that history is consistent with the defendant's account of the violent attack that caused him to shoot that person in self-defense. No guarantees, but it is a possibility, and if you find yourself in that situation, it's something to share with your defense attorney. In the meantime, go on the assumption that you will not be able to get in evidence of your opponent's prior crimes and prior bad acts, and you're going to have to your side is going to have to clearly articulate what you knew at the time. Remember, the standard is always what's known as the standard of the reasonable, prudent person. What would a reasonable, prudent person have done in the exact same situation, knowing what the defendant knew at the time? I know it's complicated. It's not the way I wish things were. I think the jury does have a right to know the prior bad acts of your opponent. Nobody watches this to find out how I think things should be. They watch it to find out how things are. And that is how things are. Be prudent, be reasonable, be safe. See you next time.